Hi, I'm Brad Emery, and this is my presentation on tort law for EDL 850. This is Module 12. So what is tort law and tort liability? Well, a tort is a civil wrong that's against another person. Um, this is a little bit different from criminal wrongs in a legal sense, in that torts are more of within civil discourse who the intent to harm doesn't usually come out into a criminal case. So what does that mean in the reality of things? Well, it means that they can claim liability, and you can be liable to pay out damages if you are found guilty in a tort case. So when injury is the result of a tort, it could be deliberate or it could be negligence. All the cases that we're going to talk about today are referring to negligence, though generally the cases in which schools are found liable tend to fall on the deliberate side of the court tort cases. They can injure your physical being, and we'll see those in a couple of quick cases here, or it can injure your reputation as well. So both of those would fall into the realm of tort liability. So we're going to jump right in. We're going to look at 5 cases here. The first is Munn versus Hotchkiss School. So Kira Munn was a student. She contracted an illness that ended up resulting in permanent damage to her neurological abilities, and she, after being sick and was treated, was left unable to speak. This came about as the result of a tick bite on a trip that they took to China, a school-sponsored trip. The Munn family sued the school for negligence. They said you should have provided the proper resources so that our daughter knew what to do and was protected from these ticks, whether that be bug spray, proper education, or just expressing caution and where they're going, vaccinations. Basically, they were saying you should have done more as a school to protect our daughter. The family actually won this case. They were awarded $10 million in economic damages and $31.5 million in non-economic damages. And this has been a high-profile case because it's kind of set a precedence for what's happening with overseas trips and trips in general concerning high school students. So that's still in the works right now. As far as what would have, if this had happened in our school, what reactive measures do we think would have occurred as a result? It's hard for me to even comprehend a case of this magnitude. I'm positive that would result in probably, if not major changes to the field trip policy. I wouldn't be surprised if it nixed the long field trips altogether. Something with this large of a damage settlement just seems like that would be the end of trips, which is, again, one of the reasons this is a high-profile case, and there's some concern about this limiting what schools are really able or willing to do with students at this point. As far as proactive measures that we could do to prevent torts like this, just making sure that parents and kids really know everything that they need to know before going on a trip or stepping into any situation. So some of the stuff that we think is common sense or just doesn't really cross our mind to share with students, we need to make sure we're making those things clear, because not all parents and students are familiar with that, whether that's, in this case, spraying bug spray, being properly vaccinated, and prepared for potential illnesses before going on a trip. That's really going to cover your bases to make sure that it's not a negligent activity if you've done everything you can within reason to prepare from a school and administration standpoint to protect those children. Our second case is Barrett versus USD number 259, which is the Wichita Public School District. This is a little closer to home for me since I'm only about an hour and a half out from Wichita. Robert Barrett was a 12th grade high school student. He collapsed after their first mandatory football practice coming back from the summer and actually died in the hospital the next day. They filed a wrongful death suit, really cited that it was probably heat stroke, as what I could tell from the court case, and the parents were suing the coach and the public school district. They claimed that this coach, Dan Johnson, was guilty of negligence and gross negligence in concerning having the kids practice in such high temperatures and extreme heat. The court did decide that the coach and the school were not held liable since he was working within the scope of his employment. Based on what I saw in the court documents there, it looked like he had given the kids plenty of opportunities for breaks and given them water breaks. So that being said, the documents I was reading said that there were still a potential that he could be charged with gross negligence, and that I couldn't find any resolution for, so I assumed that the case was dropped. If this happened at our school, the reactive measures, I think, would be really making clear when and where and how long it was appropriate to practice for various sports, just to make sure students are safe, because really that is the end goal of all schools. And we've had these are really just kind of terrible court cases and terrible results, but I know that I've yet to come across a school system that doesn't have a care for the students within their walls, and that is the end goal here. So I think the reactive measures would really be focused on making sure that practices were safe and making sure that students were safe in those. As far as proactive measures that we could prevent something like this case from happening, again, just setting boundaries and making sure coaches know when it's appropriate to practice and for how long, what it looks like to have a safe break, when we need to bring students in so that they're not running into health or medical issues with practices. The next case here is Mitchell versus Cedar Rapids Community School District. This one was really kind of hard to follow, hard to read. They didn't give any of the names. So DE was a special education student. She skipped school with some other special ed students and was actually raped by another student off campus. And her mother sued the high school for negligence. She said that they should have been monitoring her more closely, that they should have let the mother know sooner when they found out that her daughter had skipped school, and that they should have contacted the authorities, had some more measures in place to protect those special ed students. This is an instance of where the school does fall under liability. They don't get a claim immunity for this one since the student was a special ed with an IEP. And so they have more responsibility in a case like this to protect the student who has less ability to protect herself. And the findings reflect that, as the court found Kennedy High School at 70% fault, and the student was at the remaining 30% fault, and they called for $500,000 in damages. So as far as reactive measures, I'm positive that they tightened down the attendance policies and skipping classes, especially for these special ed students, to make sure that not only that their bases were covered, but again, more importantly, that the students were safe and cared for. I would imagine that one of the reactions to this is a early warning system of sorts to let parents know if special ed students are skipping or are not accounted for within the school building, and a closer monitoring of that. And really, proactive measures would look a lot the same, making sure that parents are aware right off the bat when students are unaccounted for in this high school environment, especially special ed students, and making it more difficult for students to skip school, as well as monitoring those students who have less of an ability to care for themselves, and the school has a greater responsibility, a greater duty to serve as the parent and the safeguard for those students. Here we have Cormor versus the City of Lynn. This was also focused around an elementary school. A public elementary student was pushed down the stairs with his classmates and had some injuries that resulted in permanent paralysis. Parents sued the school and the city for negligence because the school allegedly hadn't stopped the bullying that was happening with this student. Court found that the school wasn't liable because this situation wasn't originally caused by the school district. So basically the court was saying they did handle the bullying to the best of their abilities. There was nothing out of the ordinary. They were not, they being the teachers, were not being negligent or willfully wrong in putting the students near the stairs as they're lining up. That was just standard procedure. I know this was a horrible accident. The school is immune from the liability in this instance. So as far as reactive measures, I would imagine that a school in this situation would tighten down on their bullying prevention and make sure that all those complaints are taken very seriously to protect the kids. And I imagine that they issued some warnings or uh, sorry about that, some policies that kept kids farther away from the stairs so that an accident like this wouldn't happen, even if that's something as simple as lining up across the hall from the stairs and making sure to monitor students so that something like this would never happen again. As far as proactive measures, I honestly can't see proactively thinking of being away from the stairs in a situation like this, short of reading or seeing a case like this. Now knowing what I know, having studied this case, it would be good to keep students and lines away from potential hazards like that. But I think the bigger proactive step here that would be more effective, if you will, is really focusing on that bullying prevention, making sure that we've got our ear to the ground with the students and we're reaching out, we're touching base with them and making sure that they're taken care of and we're stopping these fights or disagreements before they ever happen. Our last case is Barnett versus Caldwell. This is another really tragic case. Antoine Williams was horsing around with another student in the classroom after his teacher had stepped out for a bathroom break. She had asked a hall monitor to keep an eye or keep an ear on the class. There were no adults in the room at the time. And in the course of what the court case lays out as normal student horseplay or roughhousing, Antoine fell down and ended up sustaining injuries that led to his death. The parents sued the teacher for negligence since she was out of the classroom at the time of Antoine's fall and subsequent passing. But the court did side with Caldwell on this one since she made discretionary decisions about her student supervision. They said that granted her immunity, and in more of a common English, the discretionary decisions mean that she had the right to step outside of the classroom and ask another teacher to supervise, and that was within the bounds of her teaching, and she was okay to do that. If this happened in our school, reactive measures would make sure, or would be something along the lines of an adult needs to be in to supervise the students at all time. If you need to step out, you need to have another adult step in to prevent something like this, and really that would be a good proactive measure as well. I try to practice that anytime I need to step out for something in the school. I try to get another adult in there. There have been times when I've stepped out to grab copies or something without asking another adult, but after reading this case, I can see myself changing that policy. To wrap all this up, a set of professional ethics that would benefit the tort liability of a school, really just to make sure teachers understand what negligence looks like. And while that's important and the fear of wrongdoing is all good and well, really what we're wanting here is we want to take care of all the students. So making sure that all teachers are acting in a way that's the best for their students rather than getting complacent and taking the easy way out, whether that's stepping out of your classroom and just asking someone to listen or pushing students a little hard at practice, not out of reason or within reason, but just practicing extra caution and making sure that students are safe, and maybe even going above and beyond in a proactive way to communicate to parents and students, the wisdom and the necessity to be safe and to make sure that they all understand the risks as well as preventing as many of those risks as possible. These students are in our care and they are our responsibility. We want to shepherd them and take care of them as well as we can. So thank you for your time, and this is the end of my presentation.